Bill Cosby in the news in this trial. Will the jury get it right? Are they going to deliberate for another whole day and still come to indecision? Well, of course, defense attorneys are hoping for a mistrial, and the prosecutor is saying, let's give him a little bit more time. The judge obviously agreeing with that, but perturbed, according to some reports of how the judge has responded to the time it's taking for deliberation of this.
Good morning, Wendy. Hey, this is Quentin Brogdon. I'm at Crain Brogdon. I'm one of the partners there. I've practiced almost 30 years. And in my career, at the outset, I was a prosecutor. I now do personal injury. But in the court of public opinion, I think Cosby has been convicted in the minds of many because we all know about all the other women who claim to have been molested in the same or similar way as this accuser, Andrea Costan. And in this case that we're now looking at, this jury heard only about one other accuser. No doubt some of them at least, have knowledge of the other claims, but if they're true to their oath in the case, they're looking at this particular case, and they've heard only from one other accuser, and they're focusing in, it appears, on reasonable doubt, at least some of them. They've been very conscientious. They're now, near 50 hours of deliberation, and, it's anybody's guess. The judge has said, we're going to keep going as long as this jury is inclined and able to do it. Cosby's lawyers have consistently now tried to shut the thing down, no doubt in the hopes that the prosecutor may decide not to retry it.
We're speaking with Quentin Brogdon, and I apologize for my mess up this morning. He is a partner. No worries, well, I appreciate that. Thank you. He's a partner of Crain, Lewis, and Brogdon, and as he mentioned, has had almost 30 years experience in this field. And we're talking about the Cosby case. One of the things that confuses me is how lightly Cosby seems to be taking this court hearing, this court case, because, when he came out the first day, he came out of the courthouse with, hey, 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 doing his interpretation of Fat Albert. And he got the crowd laughing and stuff. And I realized, humor probably does a lot for someone like him to win favor with people. But at the same time, there was a sort of, I had a reaction to that. And it was not a good reaction. It sort of made me reel back for a minute and go, okay, is this man taking this seriously? Is he understanding the weight and the relevancy of what is against him? Not only that he was accused, Quentin, but because he admitted to giving his dates Quaaludes. Now, whether or not they agreed to take the Quaaludes or what transpired after that, and whether they were giving permission to have sex with him, I don't know. But he did admit to giving his dates Quaaludes, and then he comes out of the courthouse with hey, hey, hey. It's like, okay, wait a minute. It just did not sit well with me, and I'm not sure that it sat well with many people.
He has to know in his heart of hearts. He just has to. He's in his 70s. That he's facing 10 years per count, and there are 3 counts here. So any sentence he gets of any length at all may turn into literally a life sentence. And that may be something, candidly, we don't know, that the jurors are considering as well. I mean, they know his age, they know who he is. That's the
they know his
room.
Well, they know his public persona.
And his public persona. And so he is attempting, right or wrong, misguided or not, to project an attitude of, what, me, worry. And I'm sure you're not the only one who reacted to that. You have to be very careful when you're in his shoes in this type of matter, not to appear to be trivializing it, not to appear to be arrogant. His defense is, yes, I gave Quaaludes to other women, and they were not unconscious. I only gave Benadryl to. She was conscious. This was consensual. It's a he said, she said. His lawyers, the strategy was to put her, the accuser, on trial, which is not unusual in this type of case.
Right.
And he didn't testify, because if he had testified, the prosecutors, they were going to be able to subject him to a withering cross-examination about some or many of these other women who have similar claims.
Yeah, and turn the screws on him, definitely. What
his lawyer's case was all of 6 minutes. They recalled a policeman who had been called in the prosecutor's case, but only briefly. But really, his case was his lawyers cross-examining the accuser, others, and the accuser's mother. The cross-examination of the accuser's mother, Gianna Constant, was one of the high points as far as legal fireworks in the whole deal.
Well, I would think that the brevity of his defense, and I would think that his cavalier attitude would make it seem as though this is just one of those paltry cases where we can all just kind of kick back and just throw it out the window. Everybody relax. Everything's fine. And it's sort of, to me, taken that tone. And it, to me, also rings of a time when women were just silly heads, and women were just, people who, you could hear from, but they were just nags. They weren't taken very seriously. So to me, this harkens back to those days when women were in that position. And I'm surprised. I'm somewhat surprised that his attorneys would allow him to be that way and would allow themselves to behave this way.
Well, his strategy certainly can backfire. Putting the victim on trial, if it succeeds, it can work, and perhaps, we don't know, perhaps the fact the jury is still out is a vindication of that strategy. Mm-hmm. But perhaps, for instance, if it's 11-1, if there's one holdout and 11 are there voting for a conviction and it mistries, mm-hmm. Then naming, the judge declares it a hung jury and there's a mistrial, then the prosecutor can retry the case. And this prosecutor ran on a campaign of prosecuting Cosby. The previous prosecutor had shut down the case, but this newer prosecutor, fairly recently elected, said, I'm going to go forward. So the odds are that this prosecutor, particularly if it's a close case where most of the jurors or many of the jurors had opted and wanted to prosecute, and there was one or a handful of holdouts, this prosecutor will retry the case, I and many others predict.
All right. Well, I've got one more question, then I got to let you go because we're already running over time, but I'm so intrigued by this. When it comes to the prosecution, would they not use their absolute best case first? Wouldn't they? So say they retry this or what have you, and say it fails again. Say it fails this time, they get a mistrial, and they retry them, and then it fails again. Would then other women be coming forward, perhaps, and bringing their case up, and in that case, wouldn't it be, I guess, lesser than this initial case? Wouldn't that she be like their number one against him, or no?
Well, the way this case came to the fore was it was newer in relative terms. Some of these women, their claims date back to the early 1960s.
Right.
Her claims date to 2004.
Right, more recent.
More recent. And so this particular prosecutor in this jurisdiction went forward on this case. Other cases could be prosecuted, but many of these claims, most, in fact, have statute of limitations issues.
Ah, okay.
So some of these women are suing him because even though their statute of limitations on the original assault, either in a civil case or a criminal case or both, has passed, he or his spokesman called them liars publicly when they came forward. So they're suing him for more recent wrongdoing, alleged wrongdoing, namely defaming them, saying things that weren't true. And so some of these women have civil cases.
And they're earning settlements for that.
Those cases are pending. Andrea Constand's case about the assault, the jury in the criminal case that's pending right now didn't hear this, but her case settled.
Right.
About 10 years ago, and he gave a deposition. Cosby, and the jury did hear his deposition testimony from that civil case in this criminal case. The standard in a civil case is different. It's only what he probably did. But in this criminal case, the standard is beyond a reasonable doubt.
Right.
So the jurors could believe that he probably did what he's accused of doing, but they could be hanging up on beyond a reasonable doubt. Did the state prove that beyond a reasonable doubt?
Oh boy, it doesn't sound like an easy case at all for the prosecutor or for the defense attorney, either or. But it's amazing to see there is support outside of the courthouse with chants and posters and all kinds of T-shirts. We love Bill. And he's using his Twitter as well. I checked it. His Twitter is somewhere where he's thanking his supporters and his fans, and he's he's kind of using that court of public opinion himself on Twitter to continue to show, hey, my people have me. Keisha Knight Pulliam, hugging him in a photograph, all kinds of things like that. But I don't know. I think he's a very smart man. I think he's calculating, and it's very possible he could get away with something that he really did do.